Greetings, all fans. Welcome to Legaleze 101. This is episode 5. We're going to talk about the burden of proof today. Burden of proof is an interesting one. It has several different layers, and Black's Law Dictionary sort of leaves us hanging in many respects on this because it doesn't even have an entry for it. But let's talk about it. Two layers of this issue are what does burden of proof mean, and what is the standard for a burden of proof in North Carolina civil claims, personal injury claims. As I said, there's no Black's Law Dictionary entry for the definition of burden of proof, so I'll just summarize it. Having the burden of proof, meaning it is the claimant's responsibility, the plaintiff, the person who is bringing the claim, to prove his case. It is not the defendant's responsibility to disprove the plaintiff's case. So in an injury law situation, this means that the plaintiff has to prove that he was injured by the other guy. That it was the other guy's negligence that led to his injury, or sometimes his intent. You can still have an intentional tort as well, although you don't see that as much in North Carolina cases. So that tells you in general what the burden of proof means. But what is our standard for the burden of proof in North Carolina civil cases? Well, in most states in the Union, it is the same. It is the preponderance of the evidence. So what the heck does that mean? Thankfully, Black's Law Dictionary does have an entry for that. So let's read what it says. Black's Law Dictionary on preponderance of evidence. As standard of proof in civil cases is evidence which is of greater weight or more convincing than the evidence which is offered in opposition to it. In typical Black's Law Dictionary fashion, that just makes it a little bit more confusing. It's a little bit more clear than some Black's Law Dictionary entries, but not as clear as it could be. So let me break it down. In order to prove your case, you have to present evidence that beats any other evidence that is presented against it. How much does it have to beat it by? Well, that's the preponderance of the evidence. It just has to beat it by a smidge, by a hair, by a nose, whatever you want to call it. It just has to have the greater weight, just a little bit more evidence. That's your burden of proof standard in North Carolina civil injury claims. Now, what's interesting is, Black's Law Dictionary has entries that are this big to tell us what these little words mean. And at the third paragraph, I think, in the Black's Law Dictionary entry states, it is that degree of proof which is more probable than not. That, to me, summarizes it perfectly. If you present enough evidence to show that it is more likely than not that your argument is correct, then you win, just a little bit, more likely than not. So let me give you an example. Let's say you have to prove your injury was caused by the defendant's negligence. Your doctor has to testify, generally, in most situations, as to his opinion or her opinion of that incident's causation of your medical damages. In order to have a chance, the doctor has to state, in his medical opinion, to a reasonable degree of medical certainty, that your injury was caused by that accident or that incident. The doc does not have to say that it was definitely caused by it, just more probable than not. 50.1% more likely than not will do it. So you just have to go a little bit above the other person's standard. Now, this is what really hangs people up in most situations when you talk to someone about the burden of proof, because they watch a lot of television and we see these crime shows that talk about how you have to prove beyond a shadow of a doubt that someone is guilty of something. Well, you do, but we're talking guilt. We're talking criminal cases when you're saying beyond the shadow of the doubt. Beyond a shadow of a doubt. That's the criminal burden of proof. The state, when presenting a criminal case against the defendant, has to prove that they were guilty beyond a shadow of a doubt. That's this much they have to beat it by. Civil standard is this much, just a smidge. Now, a good example of the difference in these burdens of proof and how they can work out is the famous O.J. Simpson case. O.J. was acquitted of the criminal charge of murdering those two folks, but he was found liable in a civil case for killing them. And the reason why is there was a different and lower burden of proof. Preponderance of the evidence in the civil case, civil right here, beyond a shadow of a doubt here in the criminal case. So a lot easier to do that in civil cases. That doesn't mean civil cases are easier, but you don't have to have that degree of proof that you have to have for criminal cases. Interesting stuff, huh? Aren't you glad you're not an attorney? I bet you are. Well, thanks for joining me again. I really appreciate it, and I hope you learned something useful. And remember, if you have an injury claim in North Carolina, please make sure you call me and I'll do my best to help you out. Thanks a lot. See you next time.